Hi folks, this is the intro video for week 9, where we're primarily focusing on registered designs. And it's an interesting week. I hope they're all interesting weeks. But it's an interesting week for me in that it's an area of IP law that tends to be overwhelmed by the others. There's so much around copyright and patents that we tend to forget about registered designs. And one of the things, I guess, that makes designs a little more forgettable is that they're not often used. Now, rather than being less interesting, and many of the textbooks sort of shove them to the back like the less welcome relative, I actually think this area is more interesting because we know about the areas where IP law has been successful, where it's used all the time. Well, what about the areas where it's not used, and why? And I think that answers very interesting questions about IP law, generally speaking, as a form of regulation. And if you find an area where the law actually there's not a lot of traffic, or there might be a lot of registrations out there, but there doesn't seem to be, it isn't big in public consciousness, there doesn't seem to be a lot of litigation. Has that stifled innovation? Has that stopped people being able to design things? And it clearly hasn't. And there's a principle in regulatory theory called tiger prevention, and it points to the situation where sometimes when you have a law, you think it's necessary because you have it, and you don't really know what the situation is when you don't. This is particularly relevant in criminal justice, but it's relevant in regulatory theory generally. And the story goes, there's a little parable about a man who's in Central Park in New York, and he's chanting, and someone comes up to him and says, "Why are you chanting?" And he says, "This is an ancient Buddhist chant that keeps tigers away." And the person says, "Well, but there are no tigers in Central Park." And the man says, "See, it's working, isn't it?" And this is the problem sometimes, and it's the argument that we need to tighten down and restrict laws further because it's the only thing standing between us and total post-apocalyptic gloom. Sometimes it's an illusion. And I think the area of fashion, and there's a video I've linked this week from Joanna Blakely that I think's very interesting, that talks about the fact that fashion doesn't use IP protection, generally speaking, except for maybe a little bit around trademarks, and it doesn't, and it actually supports the industry in certain ways. So I think it is worthwhile when you're studying areas of law to look at areas of law that are less travelled, that there isn't a lot written about, that maybe aren't as sexy or as exciting as other areas of law, but to actually look at them as a way of reflecting on their counterpoints in the other areas of law. Anyway, that's what I think. What sort of things are we going to look at this week? We'll look at the design process. One of the practical parts of this workshop I thought was actually going through the stages of the registration process, including searching, which is honestly a nightmare. But I'll let you discover that on your own. Sorry if there's spoilers there. But the classification of products and the actual process that one goes through when they're registering, I think that's quite interesting, and it's a real contrast to the copyright process where everything gets copyrighted. If they fit into the category of a copyrightable work, there's no registration process, although there used to be a similar process as the registered design process. There's also, I think, some interesting discussion to be had in the difference between what is a creative, artistic, literary work and what is a piece of design. And this is another area, I think, where the differences between the law, when it was the cultural situation in which the law was designed, and the cultural situation now is quite different. And there used to be a real dividing line between design and art. And in fact, even when I was looking at my tertiary options, you basically had an art path where you could just study fine arts at university and go off and become a fine artist and not actually learn to draw or paint, but learn to create conceptual art and so on. Or if you wanted to learn to draw or actually do anything technically with art, you had to do a commercial art TAFE qualification. And there was a very big snob difference between the artists who were seen as elite, who one day would make lots of money or not from their conceptual pieces of art, and the people who design and create and actually draw things who are seen as second class. Now that's been eroded. That culture has really changed, and there are a lot of very respected designers around the world, and design has become a more credible thing. But our law is still located in the time when basically something was a great piece of art, or it was just a piece of design. Looks like a person, it can't be art. Looks like something and it's competently painted, can't be art. There's a quote from Banksy in one of his books where he says, "Why are so many artists willing to suffer for their art but so few prepared to learn how to draw?" Very much a product of that era. Nowadays, those things are more merged. So again, it's an interesting point of reflection as to why we've got this massive legal difference between the concept of design and the concept of creative work that are located in a particular cultural history. And if we created these laws now, they might be quite different. Anyway, enough of a ramble there. Hopefully this will be an interesting thing to discuss in the workshops this week.